This is Barry Zalma speaking for Claim School Incorporated with another story of true crime insurance fraud. These stories were taken from my 54 years as an insurance claims person and insurance claims lawyer. All are true. All are changed with the names and places to protect the guilty. This story, number 33, is called the Sleaze. The Sleaze was not a nice man. He learned the safe way to steal in prison. A Superior Court judge had sentenced him to 2 years in state prison for forging his mother's will. His cellmate, an armed robber, bragged about his successful brother. The brother had found a new career, claiming the theft of small pieces of jewelry on homeowners' policies. Insurance companies always paid, whether he owned the jewelry or not, rather than fight. His cellmate explained how prosecutors had no interest in this type of crime. Insurance companies, fearing punitive damages and bad faith verdicts, would pay even when the claim was obviously fraudulent. The Sleaze vowed that when he got out of prison, he would pursue this safe form of crime. The Sleaze was a man of his word. Immediately after leaving prison, he bought a tenant's homeowner's policy. He asked for and received, without question, a $10,000 jewelry extension from the company. His limit of liability, instead of the standard $1,000 for jewelry, was $10,000. Within a month of buying the policy, he reported the probable theft of a $10,000 ring. He told the adjuster that he was at the Beverly Wilshire Hotel meeting with a business associate. He removed his ring to wash his hands in the men's room and forgot to replace the ring. Returned to his lunch and realized the ring was missing about the time he finished lunch. He immediately went back to the restroom, but found the ring missing. He reported the possible theft to the men's room attendant and to the hotel security office. He told the adjuster that the ring was a family heirloom given to him by his father a week before the father died. He had no appraisals or receipts. He had nothing in writing that proved he owned the ring. He had no photographs showing him wearing the ring. He was willing, however, to swear that he owned the ring and that it was probably stolen from the restroom in the Beverly Wilshire Hotel. The insured, the Sleaze, having read up on jewelry, described the ring to the adjuster in detail. He told the adjuster that it was a rather heavy ring. It was made of 18-karat gold, set with a 4-carat center diamond, and on each side were 2 baguette diamonds totaling half a carat. He did not know the gemological grade of the diamond nor its color. He admitted the center diamond was not a perfect stone. It had a slight yellowish tinge to it. He could see no flaws in the diamond with his naked eye. The adjuster verified the Sleaze's story by interviewing the hotel men's room attendant and the security officer. Both agreed that the insured reported the loss of a ring to them. Neither recalls seeing the Sleaze wearing the ring before he reported the loss. He was not a regular guest of the hotel, and they had never seen him before or since he reported the loss. The jeweler evaluated the description of the Sleaze's ring and told the adjuster it was probably a Gemological Institute of America J or I color. He could not replace it for less than $3,500 per carat. Adding to the cost of the diamond the cost of 4 baguettes and the 18-karat gold, that the jeweler did not believe he could replace the Sleaze's ring for less than the $10,000 policy limits. The adjuster, faced with a sworn proof of loss and no evidence that the Sleaze was lying, paid the policy limits and closed his file. The Sleaze was pleased. The work was easy. The effort required were minimal. With only a $300 investment in premium, he had made in less than 2 months $10,000, more money than any annual salary he received before he went to prison. He invested a small portion of his profits into a new policy with a different insurer, and in less than a year collected $75,000 in claims payments. The Sleaze did not know that there was an organization known as the ISO All Claims Database that included records of the old Property Insurance Loss Registry, the PILR, and the National Insurance Crime Bureau's records, the NICB. Although all property insurers are not members, many are. Each member records in the registry all property losses presented to them. After a year of successful insurance fraud, the Sleaze tried his trick on a company that was a member of the NICB. When they entered the Sleaze into their system, they found recorded in the All Claims database 5 of his last 9 insurance claims. They contacted each insurer and found that 2 of them had paid claims on property that appeared the same as that claimed by the Sleaze. One, which did not have similar property, had the same loss situation. The Sleaze had told his present insurer that his scheduled diamond earrings had been accidentally thrown out with the Christmas trash. He had told his prior insurer that his scheduled diamond necklace had been accidentally entangled in wrapping paper and thrown out with the wrapping paper for his wife's birthday. The coincidences were too great to ignore. The insurance company retained counsel to examine the Sleaze under oath. He appeared for the examination under oath confident in his skill and willpower. He testified clearly and held nothing back. He admitted the previous losses. He admitted his criminal record. He denied that the claim was fraudulent. He challenged the insurance company to deny his claim. He informed them that he had heard of the tort of bad faith and he was looking forward to pursuing them if they refused to pay his claim. Undaunted, the insurance company denied the claim. It informed the Sleaze the reason for the denial was that the claim was made with knowledge that it was false and fraudulent. The insurer also rescinded the policy of insurance because the insured had failed to reveal on his application the prior losses and several prior cancellations. The Sleaze filed suit in propria persona, acting as his own lawyer, for the value of the earrings and for punitive damages because of the bad faith of the insurer in not paying his claim. The Sleaze pursued his lawsuit vigorously. The board of directors of the insurer had laid down a specific requirement on all its claims personnel to never pay a fraudulent claim. The company committed its assets to spend as much as necessary to defeat fraudulent claims. It would do so even if the cost of defense exceeded the value of the property that was the subject of the claim. They also committed to aggressively and legally attack the insurers who presented fraudulent claims through the courts. Therefore, after the complaint was served, the insurance company not only answered the allegations made by the plaintiff, the Sleaze, but cross-complained for fraud. Since California does not allow suits by insurers for breach of the covenant of good faith and fair dealing, it does allow for common law fraud claims. The insurer demanded damages, including punitive damages, from the Sleaze. Based upon the evidence already gained at the examination under oath, the insurer filed a motion for summary judgment seeking judgment by the court that they owed nothing to the Sleaze on his complaint. The motion also sought judgment of $20,000 in attorney's fees and investigation costs incurred as a result of the fraudulent claim. Finally, the insurer asked for punitive and exemplary damages to deter future fraud. The court, much to the surprise of the Sleaze and the insurance company, granted the motion for summary judgment and awarded the insurance company $20,000 in compensatory damages and $50,000 in punitive damages. The Sleaze was incensed. He went to the courthouse and ordered a copy of the original file from the clerk. The clerk, as is their practice with such public records, handed the entire file to the Sleaze. The Sleaze removed the judgment from the file and, using a public typewriter in the courthouse building, typed the words at the bottom of the judgment, Judgment stayed pending appeal. He then returned the judgment as he had amended it to the court file and purchased a certified copy of the now amended judgment. He served this copy on counsel for the insurance company to stop them from executing on the judgment. Counsel for the insurance company, shocked at the stay without a bond being required, contacted the clerk. The clerk informed him that before any document being filed in the court's file, it must first be microfilmed. At counsel's request, the microfilm was pulled and a print of the microfilm copy of the judgment was made. The microfilm copy, of course, did not have the stay language on it. 3 weeks later, in open court, a motion was heard to correct the court's record. The motion was granted, and the court referred the Sleaze to the district attorney for prosecution for tampering with the court file. He was never prosecuted. However, while the Sleaze and counsel for the insurance company argued the motion before the court, the Los Angeles County Marshal served a writ of execution on the Sleaze's brand new car to satisfy the judgment. The marshal notified the Sleaze that the car was taken in open court. The Sleaze was furious. He threatened physical harm to the attorney for the insurance company. Counsel was concerned by the threat. She knew the Sleaze's first criminal conviction, by searching his criminal records, was for a violent act of raping a Girl Scout cookie salesperson who made the mistake of attempting to sell her cookies at his door. At the future court appearances, counsel was always accompanied by a bodyguard, paid for by her law firm and the insurer. The Sleaze would not let the matter rest. He filed suit in Superior Court, naming counsel in the insurance company for fraud in the taking of his automobile. The insurance company had to retain new counsel to defend its attorney and itself in this lawsuit. When the suit was unsuccessful, the Sleaze filed small claims court actions alleging fraud and hoping the insurer or its attorney would fail to appear. When counsel appeared at the small claims court action, the Sleaze, who was present, faked an illness and begged for a continuance. When this was unsuccessful, judgment was entered on the small claims court action for the insurance company and its counsel. On the surface, the Sleaze was unsuccessful in his fraudulent claims against the insurance company. He was successful in committing fraud. He was successful in raising the reasonable cost of defending a fraudulent insurance claim beyond logic. He placed a lawyer in fear of her life and cost her law firm and the insurer she represented the cost of a bodyguard. Anyone who believes that insurance fraud is not a violent crime never met the Sleaze. He kept trying, but his modus operandi had become a matter of knowledge throughout the insurance industry, and the Sleaze was no longer successful in his insurance fraud attempts and went on to other types of crime. This video was adapted from my book, Insurance Fraud Costs Everyone, which is available as both a Kindle book and a paperback. As you view this video, I would appreciate it if you would click on the like button and the rumble button, depending on which service you use to view the video. Thank you for your attention.